All right, if you're gearing up for the Queensland bar exam, let's talk about a topic that is an absolute classic exam trap, the delay rule. In this explainer, we are going to break down Uniform Civil Procedure Rule 389, piece by piece. The goal? To make sure this complicated rule becomes a serious point score for you. Let's jump right in.
So, picture this. You get an exam question, and there's a case that's just been sitting there gathering dust. Then, all of a sudden, the other side wants to make a move. Or maybe it's you who needs to get things going. What do you do? Well, this is the exact problem that UCPR 389 is designed to solve. It's all about managing litigation that's gone completely silent.
Okay, here's our game plan. We'll start with the rule itself, Rule 389, and look at why it even exists. Then, we're going to dive deep into the court's discretionary test, the famous Tyler criteria, and see how it works in practice. And we'll wrap up with some of the key nuances and traps, plus your ultimate exam takeaway. Let's get to it. First things first, let's nail down the black-letter law. We're talking about Rule 389 of the Uniform Civil Procedure Rules. And look, for your exam, knowing its two key subrules by heart is completely, 100% non-negotiable. You have got to see the critical difference here. After 1 year of nothing happening, Rule 389, Subrule 1 kicks in. This is pretty simple. It's a procedural step. You just have to give 1 month's notice saying, hey, we intend to proceed. But once you hit that 2-year mark of inactivity, the stakes get so much higher. Rule 389, Subrule 2 is a hard stop. You literally cannot take another step without a court order. You have to seek leave from the court. And here is the most critical point. And this comes from the case of Way v. Primo Rossi. The 1-year rule and the 2-year rule are totally separate hurdles. Sending a notice under Rule 389-1 does not stop the 2-year clock for Rule 389-2. You can't just send a notice at the 23-month mark and think you're in the clear. Nope. If 2 full years of inactivity go by, you need the court's permission. Full stop.
So, you might be wondering, why do we even have Rule 389? Well, understanding the why, the policy behind the rule, is what takes a decent exam answer and makes it a great one. It gives you the scaffolding to build a really persuasive argument.
The core reason really comes from this massive case, Tyler v. Custom Credit. Justice Atkinson pointed out 2 huge problems with delay. First, it makes the public lose faith in the justice system. And second, and this is the big one, it makes it harder and harder to have a fair trial because memories fade, evidence goes missing, you get the picture.
So let's just break that down a bit. Rule 389 is really a balancing act. It backs up UCPR Rule 5, which says everyone has to act quickly. It also gives defendants some peace of mind so they don't have this old lawsuit just hanging over their heads forever. And at the end of the day, it's the court's way of keeping an eye on things and making sure these stale cases actually get dealt with.
Okay, now we're getting to the most important part of your analysis. When a party asks for leave under Rule 389-2, the court has a really broad discretion. And the roadmap for how it uses that discretion comes straight from Tyler v. Custom Credit Corp. These 12 factors, this is your exam checklist.
Let's run through the first 6. The court looks at how old the whole dispute is and how long the case has been running. It'll take a quick look at the plaintiff's chances. A case that looks like it's going nowhere has less reason to be brought back to life. And crucially, the court will look at the history of the file. Is this a one-time thing, or is there a pattern of delay? And of course, who's to blame for it?
Now for the final 6 factors. The court thinks about practical things, like how far along the case already is. Number 9 is a really interesting one. Delay caused by lawyers isn't automatically held against the client, but it's definitely part of the mix. But you've got to pay close attention to these last 3, because this is where the real battle is won or lost. Is there a good reason for the delay? Has the other side been prejudiced? And the absolute ultimate question, can a fair trial still happen? Now, it is so important to remember this. These 12 factors are not some mathematical formula where you just tick off boxes. It's a balancing act. The court's discretion is everything, and it's going to weigh all of these factors in the specific circumstances of the case, all to try and get to a just result. So, how does this balancing act actually work in the real world? Let's check out a couple of contrasting cases to see how judges really weigh these factors. So, in Vlees v. Commonwealth, the court said no, it refused to grant leave. And the big takeaway here? When you have extraordinary, unexplained delay, and it's mostly the plaintiff's fault, and it causes real prejudice to the defendant, well, that's often a fatal combination. In this case, those factors just weighed so heavily that they tipped the scales against granting leave.
But now, let's contrast that with Drain v. Berlin Tower. In this case, there was also a really long delay, but the court granted leave. What was the difference? The delay was caused by the plaintiff's lawyers, not the plaintiff themselves. This shows you just how important Factor 9 can be. The court is often a lot more forgiving when the actual litigant isn't the one to blame.
You know, when we talk about prejudice, it's important to realize not all prejudice is created equal. As the court made clear in Lillis and Loya lawyers, the real issue isn't just the normal stress and anxiety a defendant feels because of a lawsuit. The question that carries the most weight, by far, is whether the delay has actually damaged the defendant's ability to get a fair trial, because a key witness has died or documents have been destroyed. That's the prejudice that really matters.
All right, we've got the basics down. Now let's dig into the details that are going to make your exam answer really stand out. These are the common traps and the more advanced points that can make all the difference.
So the clock for Rule 389 starts ticking from the last step taken. But what actually is a step? Well, it has to be a formal action that moves the case procedurally closer to a final decision. Just writing letters back and forth or having negotiations over the phone, that won't cut it. It has to be an official action inside the court process.
And here are some absolute classic exam traps. None of these things reset the clock. Giving that 1-year notice under Rule 389, Subrule 1, not a step. Going to mediation, not a step. Filing certain notices or making an application where no order ends up being made, also not a step. Knowing this list could save you from making a really critical mistake.
Here's another advanced point you need to know, and it's about limitation periods. The old view, from the English case Burkett v. James, was basically that if the limitation period hadn't run out yet, refusing leave was pointless, because the plaintiff could just file a whole new lawsuit. But the modern Queensland approach, which is influenced by UCPR Rule 5 in cases like Bendick v. Cloud, is very different. Now, starting a second lawsuit after the first one was delayed could actually be seen as an abusive process. So while an open limitation period is still a factor, it is definitely not the get-out-of-jail-free card it used to be.
Okay, we have covered a lot of ground, so let's boil all of this down into the most critical points that you absolutely must take with you into that exam room. Think of this as your mental checklist for any Rule 389 problem.
Here it is. Number 1, absolutely nail the difference between Rule 389-1 and 389-2. One is notice, the other is asking for leave. Number 2, use those 12 Tyler factors as the skeleton for your answer. Go through them one by one and apply them to the facts in front of you. And number 3, always bring your argument back to the ultimate question. Has this delay fatally damaged the chance of a fair trial? Everything really hangs on that.
And as you're wrapping up your analysis, I want to leave you with this one last thought. Try to put yourself in the judge's seat. After all the legal arguments and all the factors, the question they're probably asking themselves is a very human one, and it comes right from Factor 11 of the Tyler test. Has this person given me a satisfactory explanation for the delay? So often, your entire application hangs on the answer to that simple but incredibly powerful question.